Well, I think we should get started. I recognize it is the summer, and even sometimes when we have really high registrations, some folks don't get to it, but let's stay on schedule here. Welcome, everybody. My name is Rob Del Giorno. I'm the chair of the compliance group here at Garfunkel Wild. I'm joined by two of my colleagues from the compliance group, Andrew Coe and Vanessa Giunta. Sorry. And we happen to spend the last probably couple of years dealing with significant enrollment issues, terminations, revocations, deactivations for our pharmacy clients. And we thought that it's a good idea to kind of take the knowledge that we've gained from these experiences and to share it with our clients and with other pharmacies out there. Um, it's really been quite a tumultuous couple of years for our pharmacy clients. Um, and there's been a lot of difficulty that's been experienced in dealing with the Medicare contractors and processing applications, ripple effects with commercial payers, ripple effects with Medicaid, depending on your jurisdiction. And so it's a good time for pharmacies to kind of check in and make sure they understand their obligations. The real focus today is going to be on that 855S application for your DemiPost pharmacy enrollments. And to make sure you're hitting all the areas you need to hit, doing the things you need to do, and more importantly, not missing the things you shouldn't miss. So with that said, let me turn it over to my colleagues who've really worked hard to put together a great discussion for us today. Take it away, guys.
Well, thank you for joining us today. So, Medicare deactivations and revocations are currently on the rise. What this means is that there's a significant amount of enrollment and revocations. In the fiscal year of 2022, there were approximately 123,000 deactivations and 2,290 revocations of enrollments. CMS credits site visits and revalidation requests among the initiatives contributing to deactivations and revocations. More than 1 million enrollment records have been deactivated or revoked since 2012 alone. Regarding some specific enrollment issues, in the fiscal year of 2022, CMS denied approximately 718 enrollments and revoked 4 enrollments as a result of fingerprint-based criminal background checks or a failure to respond to the request. The consequences of non-compliance for DemiPost pharmacies. Dire consequences for a failure to timely and completely respond to enrollment relate to notices from CMS. Billing privileges may be terminated and enrollment bars can span from 1 to 10 years. And if you're deactivated, you can have gaps in enrollment status, such as Rob had stated, and this exposes your claims of recoupment. As a result,
Just hold on one second here. Just understand, everybody, what can happen is, and we're gonna get to all of it, but if you slip up here with your applications, they have a few things out there that they can put you on just for enrollment paperwork purposes. They can deactivate you. They can, which means turn your number off, but not kick you out of, the Medicare enrollment. They can revoke you, which means take away your number. And then they can, if they're going to do that, they can bar you from trying to get back in years later. But this deactivation, it sounds harmless, but if you have a deactivation that gets dated back, what Andrew's talking about, all that money that you had collected can become subject to recoupment. So all of these things, the same thing with the revocation, if it dates back to a particular period, it starts to tag dollars that already came into your pharmacy. So it's important you pay attention and understand these nuances.
Medicare enrollment requirements. DemiPost pharmacies must meet specific enrollment requirements to obtain and maintain their billing privileges. These include complying with quality standards and obtaining accreditation from CMS-approved accreditation organizations, unless you're exempt. And we've seen this many times where pharmacies will come to us and they're not quite certain what are the CMS-approved accreditation organizations. So we can point you to the right direction as far as the CMS website, which lists the accredited organizations which can give the approval. We'll cover supplier standards in greater detail later in this presentation. In order to supply Medicare to Medicare patients, suppliers must use the 855S enrollment application form. This is both available by paper copy and online on the PAYCO system. The application process involves verifying that the supplier meets all Medicare requirements before granting billing privileges. The CMS 855 form is captured on the screen above. This is what the cover sheet looks like, and who should use this form? Many different types of DMEPOS suppliers, including pharmacies, must complete this form to enroll in the Medicare program and to receive a billing number. This includes suppliers who are new applicants, responding to revalidation requests, reporting changes of information, or for reassignments of benefits. When you use the paper-based form, applicants should always make sure that they're using the most current version, because we've seen this where if you go on Google, even though a new version is out, there are links that are still active that go to prior copies. Pharmacies can use this form to enroll, report changes, enroll a new business location, respond to revalidation requests, reactivate your billing number, and voluntarily terminate your billing supply number. You want to be careful when you're using this form, make sure that you're filling out the appropriate sections. When you are filling out the CMS 855 form, you want to make sure that the information is accurate in order to avoid delays. Complete and accurate information is required on the application, and any change to existing enrollment information must be reported within 30 days of the effective date of that change. All supporting documentation must be included with the application. Supporting documentation can include documents such as your liability insurance, a copy of your surety bond, electronic funds transfer authorization agreements with a voided check or a bank letter. When you are using the PAYCO system to upload it, you want to make sure that you're carefully checking that the right attachment is being uploaded. So you have to make sure that you're organized, all the PDFs and the informations that you collected are in the right spot. When you upload it, you also want to confirm that it actually is uploaded to the system. There have been times where clients have come to us and they tell us that they're certain that information was uploaded, but then when we go into the PAYCO's application, although they uploaded, they may not have clicked the confirm, so the document actually did not upload to the system. For changes of information, there are specific sections that must be completed depending on the type of change, and this includes new location, ownership, or insurance. Another issue that we come across is the issue with the legal business name not being listed and the TIN not matching. You want to make sure that for these applications that they match exactly in both the PAYCOS and the National Plan and Provider Enrollment System. The name should also match a bank account name used for the EFT funds and on any IRS documentation listing the business name.
All right, let me just pause for 1 second here. Finish the slide and then let me add a few points I want to make.
The 855S form is essential to enrolling as a DMEPOS supplier. It collects the information about the supplier, organizational structure, ownership, practice location, and compliance with the supplier standards. The form also requires that the pharmacy provide financial data and evidence of compliance with applicable federal and state regulations.
All right, I'm going to test you on the fly. Are you able to drop back a slide? Are you more sophisticated than me? Okay, terrific. So here's a few things what are your big takeaways on your 855S? Because what we did with these slides, just so you know, is we really included, some of them are dense because we wanted to get the information into them because we're sending these to you and everybody who registered. When we're done, a recording is made. You're going to get the slides. You're going to get the recorded presentation with the slides. And so you'll have a resource that you can kind of just file away if you have issues that come up, or if you have questions, you have something you can go back to that's more meaningful than kind of a plain open-ended sentence. So the 855S you need to think about as your gateway to your Medicare enrollment, all right? And it's also the way you maintain your enrollment in good standing. And so it really lays out pretty well the things that you need to be doing and that you need to be updating. So it gets you into Medicare, and staying on top of it keeps you in Medicare. And I want to highlight this 30 days issue. There's certain information that has to be updated within 30 days. I think there may be a 90-day depending on it, but you really need to make sure that if you've got changes of ownership going on, you've got new store locations, you're staying on top of these things because they do require you to go in and update them. And if you don't, and CMS finds out through some other channels that this has changed, you're getting a notice in the mail. And now you're coming to folks like us for help because you now have your enrollment in jeopardy. So remember, this form it's important, it's your gateway, it keeps you compliant, and you need to anytime you're doing things with your stores and changing things, you got to be thinking, okay, hey, do I need to go back to that form? Do I need to go to my 855S and update anything here? I mean, we'll talk about some more of that along the way, but keep that in mind as you're working. Go ahead. Thanks for letting me jump in.
Thanks, Rob. So PACOS is the online enrollment system that's used for the 855S and the 855B. This allows you to create a username securely and to submit the information right online. So what's the difference between the PACOS and the paper application? What we see is that the PACOS applications are processed more quickly. They're paperless, so it's easier for the contractor to review. On top of that, the PACOS system is nice because you can log in real time and it'll give you a status. It'll say it's still under process or under review, and you don't get that benefit with a paper application once it's submitted. PACOS is tailored to ensure that you only supply information that's relevant to your application. It also has a lot of videos and tutorials that you can use if you have any issues trying to fill in the application. You can easily check the history of the forms, which I had discussed previously. This helps to make sure, let's say you do get a notice in the mail that is claiming that certain information was missing, you can go back into your form history and look at your submissions to see if in fact the actual supporting documentation was submitted. We do understand that people will still rely on the paper application. It's useful if you're not as comfortable with the electronic process or if you have technical issues. You want to avoid delays, rejections, and revocations. Examples of pitfalls and avoiding delays, rejections, and revocations include choosing the correct ownership and business section to use. So in the actual application itself, it's under section 5. Also, each individual reported for a section 6A ownership interest and or managing control information must have a corresponding section 6B report for final adverse legal action. So when you're filling this information out, you want to make sure that you're not looking at each section separately. You want to look at the application as a whole and compare and make sure that everything is consistent. You want to complete and include a newly signed section 15 certification statement when required. You want to provide all required, unexpired, and correct supporting documentation. For example, what we've seen is when pharmacies go in and provide this information, they may just grab a surety bond that is expired because that's what's on their computer or what's easily accessible. You want to make sure that it's still effective when you're submitting it. Additionally, you want to report all managing employees and the correct title of each managing employee. This includes either a W-2 managing employee or a contracted managing employee if they're not a W-2. And a managing employee means a general manager, business manager, administrator, director, or other individual who exercises operational or managerial control over, or who directly or indirectly conducts the day-to-day operations of the supplier. Again, this is either under contract or through a separate arrangement. You want to submit accurate and complete submissions. in order to maintain and obtain your Medicare billing privileges. Typically, the MAC determines if there's missing information on the application and you'll receive a notice. Suppliers have 30 days to respond completely and accurately to such requests. What we've seen is that the request may not always be clear, so it's important when you get this notification to reach out in order to get clarification. For example, they may just cite a general supplier standard without actually explaining what is missing. The MAC will reject applications if the 30-day period has lapsed without response, and it's up to the MAC's discretion to make a second request for the development. The MAC only has to reach out once with all development issues included in one request, and often chooses email. Make sure that you're checking your email and that the email that's on file is regularly checked. What we also see is sometimes an old email address will be put on file and there could be a change in who is in charge of monitoring it, and the email address never gets updated, so then those emails from the MAC are overlooked and never responded to. Responding to development requests related to revalidation. While a non-response to development requests in other scenarios usually results in a rejection of the application, there are different consequences here. When a MAC requests a revalidation application and subsequently sends a development request for missing and or clarifying information, suppliers only have 30 days to respond. The response has to be complete and accurate, and if not, in the context of the MAC, they have authority to not only reject the application, but this is significant, they can also deactivate the supplier. A new reactivation application will then be required, and there may be gaps in enrollment and billing privileges, which can impact the claims that were billed.
Hey, not only that, but you're gonna get a new PTAN number too. So, there can be a number of headaches. And just when you're done today, go in, whether you're in PCOS or give Medicare a call. Make sure the contact information they have on file, what Andrew said in the past, so that's so important, has a way to get to you. You don't know how many of these come in because somebody missed an email. Somebody didn't check the mail. Talk to your folks at the front. If mail's coming in, it's from Medicare. Make sure it's getting to ownership. Make sure that it's not just sitting there or somebody throwing away, or if it's going to your billing company, make sure that's coming to your attention, because they're not going to be very sympathetic if you didn't do the work in the front on the front end to make sure they can get in touch with you the right way. It's our obligation. So if you don't do anything today about this, do that.
And it's really important to have a policy and procedure in place in order to timely receive it, because again, it's a short time frame. If something's missing or there's an issue with your liability insurance, for example, you want to be able to have enough time in order to have effective liability insurance and get a copy of the documentation needed to submit. Requirements for DMEPOS pharmacies. The following is the abbreviated version of the supplier standards, and we won't go into every single one in complete detail, but for purposes of this presentation, we will discuss and provide examples of the standards that we regularly see from our pharmacy clients. These are the supplier standards which are cited in all the communications, and they refer to the regulation. Next, I will turn this over to Vanessa, who will give an example of commonly cited standards as a basis for revocation.
Yeah, that's great. That's great. There's a lot of things in there. Like we said, this is a good resource for you to go back to if you want to go back through the supplier standards. And we did highlight those. So Vanessa, take it away.
Sure. So the ones that we bolded there are ones that we've seen pretty frequently in these communications from CMS. So Andrew, if you want to move to the next slide so we can just take a close first look. This is something that we see a lot of as a basis for revocation. It involves warranty coverage. So a supplier has to notify beneficiaries of warranty coverage and honor all warranties that are available under state law. And this includes repairing or replacing Medicare covered items for free if they are under warranty, So pharmacies should consider using an equipment warranty information form like the template shown here, which is from the Mac Novitas Solutions. And they should be prepared to submit signed forms during an on-site inspection or keep it on file so that you could use it as part of a corrective action plan if you have to. Okay.
Hold on, hold on, hold on. Before we
Oh.
go on, just go back to that slide again. I want to point something out. I think you probably have a few of these in here. This one has come up in the context of the inspector coming to your pharmacy for a survey. Hey, take out the book. Let me see the documents you're supposed to have. We've seen some things where pharmacies are given, only a few minutes to produce this. With the inspector saying, hey, don't worry about it. You'll just get a letter and you can send it in then. Everything's fine. It's not a big deal. It is a big deal. And if somebody is time pressuring you there, you should ask them to wait, particularly if you know you have the document. Because that letter we have seen coming in is not just a follow-up request for some additional documents like this, but it's a revocation notice because you're non-compliant with supplier standards. So I would get all of your things here in order, right? From a practical standpoint, what's your takeaway? Make sure your house is in order. Have your book ready. Have all these documents ready because that letter that inspector, kind of nicely pretends is just going to be a nothing letter is a very serious letter. All right, go ahead.
So for general liability insurance, this is another one. You want to ensure you have comprehensive liability insurance of at least 300,000. That should cover your business, customers, and employees. And this also includes product liability if you manufacture items. You want to be sure to submit a copy of the actual certificate of liability with your enrollment application and revalidation application. And you want to be sure that the contractor's name and address is actually on the policy as a certificate holder. They'll ask for proof of that. It's also important to note that professional and malpractice insurance is different from comprehensive liability insurance, and we've seen deactivations occur because suppliers have confused these types of insurance when they submit their supporting documentation or when they're answering development requests, and that can lead to problems down the road. They'll treat it as if you did not respond to the request at all. And lastly, you want to be sure to quickly respond to revocation letters about insurance lapses, even if it's a mistake on the contractor's end. You want to provide the proper documentation rather than just assume or wait for CMS to figure it out and figure out that it was their mistake, because they likely won't. For deliveries and instructions on using Medicare covered items, you want to maintain proof of delivery and proof of providing these instructions. So this means keeping documentation, again, that shows that beneficiaries are receiving the necessary information and instructions on using Medicare covered items. So something like using samples of written instructions, item forms, proof of delivery forms, and then keeping the signed copies. And we note here that Medicare requires this delivery documentation to be kept on file for 7 years from the service date. Suppliers also have to answer questions and respond to beneficiary complaints, and they actually have to maintain documentation of these contacts. So this is best done with a complaint resolution protocol for addressing beneficiary complaints related to the supplier standards. And you want to keep these written complaints, correspondence, any notes of actions to be taken, because the information has to be available at the facility and then available to CMS upon their request. So for this, it's helpful to use a standard protocol for resolving beneficiary complaints as a form, and then using a beneficiary complaint log so that you're always prepared to submit these signed forms during an on-site inspection or to provide them as proof that you complied with the standard if you ever have to submit a corrective action plan.
For this particular standard, you want to make sure that's a more formal notebook or handbook that's in place. You don't want just a 3 spiral binder with just paper in it that has nothing filled in, because there have been times where the on-site inspection happens and the surveyor is asking for the log, and there may be just a binder with nothing in it that is provided to the surveyor, and they don't find that is sufficient to meet this standard.
Yeah, that's right.
You
I
know,
think the next slide. Oh,
by the
sorry.
way, when we talk about some of these things with the insurance and what I was saying about changes before, oh, some things changes. Um, and I know we have in some of the slides, but those changes are what you switching your broker, you're getting a better insurance deal. You sure that broker got your documents into Medicare? Oh yeah, don't worry, we're going to do it. We've got a lot of cases where they don't get in there, and we're in the middle of, a mess, because somebody overlooked something. So, yeah.
In this slide, we just have some example protocol forms, templates from Medicare contractors that you can use in these situations. So suppliers also have to meet surety bond requirements, which we've brought up before. And some of the key requirements here include having a minimum continuous surety bond of 50,000 or more if you're required by CMS due to some history of adverse legal actions. You cannot have a gap in coverage if the supplier cancels and obtains a new bond. And the term of the initial surety bond has to be effective when the application is actually submitted. And you want to keep in mind that for ownership changes, if the bond is effective later, at a later date, then the new billing privileges will start from that bond's effective date. So that could also cause a gap if you're not aware of these overlapping dates. And new locations also will need a new surety bond or an amendment to your existing bond. In addition to this, you also want to be sure that you respond promptly to any revocation letters about the surety bond. So even if the coverage is still effective and it just seems to be an error on CMS's side, again, like the liability insurance, you don't want to just assume that CMS is going to catch this and then correct the error without you responding and providing the documentation. Suppliers always have to provide complete and accurate information on the supplier application. Like we've been saying, any changes reported within 30 days. Some significant changes might include ownership changes, adverse legal actions that come up, practice location changes, but either way, CMS cautions suppliers to always report any change within 30 days to avoid revocation, with very few exception. Another example we've seen cited involves changes like a new product line that would require accreditation. And in these instances, it can get really confusing because CMS can penalize a pharmacy for failure to notify them about changes in the pharmacy's accredited products and services that it's offering. So because of this, it's very important to ensure that all of your staff are aware of billing procedures for specific DME that you're supplying, especially if the pharmacy is not exempt from accreditation. Suppliers have to maintain and replace at no charge or repair Medicare covered items rented to beneficiaries, either directly or through a service contract. So this means that pharmacies should consider keeping protocol forms again to file in order to document maintenance, replacement, repair, and be prepared to submit these records of any maintenance or repairs or exchanges if they've occurred. And we note here that these requirements apply to Medicare covered items that are actually rented to beneficiaries as compared to other types of DME. You might still have documentation on file for exchanges or repairs or maintenance, but this specifically applies to rental DME. So we're going to talk about accreditation requirements and exemptions. So in order to supply Medicare DME POS, suppliers have to be accredited, like we were saying before, by a CMS-approved national accreditation organization. But certain pharmacies can be exempt from accreditation if they meet the specific criteria. So this criteria includes being enrolled in Medicare as a supplier for at least 5 years, and then keeping DME POS billing below 5% of your total pharmacy sales for the last 3 years. So you might wonder, what CMS means by pharmacy sales in order to meet the exemption. They define this as sales which are in a separate pharmacy account for entities that have that kind of accounting breakout. But for smaller pharmacies, they might not have these accounting breakouts, and then they just refer to the total gross sales of the pharmacy, so 5% of that or less. So to qualify for accreditation exemption, you would have to attest with an attestation exemption form to the following criteria. So that includes, what we just covered before, enroll for 5 years, no unrescinded final adverse action in the last 5 years, the 5%, less than 5% pharmacy sales, and the exemption attestation itself, in order to be effective, actually has to be signed by the authorized or delegated official that you listed on your 855S application. So it's important to be aware of who that actually is. If you have multiple owners of a pharmacy, it might be one of you, and you have to make sure that it's that person. Some pharmacies that are ineligible for exemption include new pharmacy chains because they wouldn't hit that year, that time frame mark. Those with changed ownership or legal entities that have changed, or those with different taxpayer identification numbers that are different in the last 5 years. So to avoid revocation, we have some tips related to this accreditation issue because it comes up so often. If the pharmacy has more than one practice location, each location has to have a separate attestation for exemption. New locations of multiple location pharmacies are, again, they're not going to be considered enrolled for the 5-year minimum. And pharmacies with a change of ownership, new legal entity, they're not going to qualify. And it's important to note that if the pharmacy is no longer accredited or just doesn't qualify for exemption, but if you're still billing for accredited products, then your Medicare billing privileges could be revoked. They're at risk. And also, if the pharmacy no longer meets the sales criteria, let's say you're billing more than 5%, or you've experienced some sort of final adverse action that you haven't reported, then that's also going to cause you to be subject to the accreditation requirement. And you also have to notify the contractor again within 30 days. And you want to be sure that during an audit, or if you receive a letter to ask for documentation to prove that you're still meeting this criteria, you have to have this documentation on file. Usually an accountant certification or tax returns would be used for that. So I'm going to talk about some common reasons for noncompliance. So finding of noncompliance can happen for various reasons, as we've covered. Some of the other issues we may not have already mentioned include not maintaining a valid state license, or failing to report adverse legal actions, or if you're confused about what actually counts as an adverse legal action to report, you can certainly ask us. This is why it's important to regularly check your compliance status, and you want to address any issues quickly to avoid any of these penalties. It's also important to remember that, again, if you don't respond to development requests, or you're not checking for them coming in, again, in certain contexts, it can lead to deactivation, which is critical to keep in mind. Again, could just come through one email and then that's it. So we're going to talk about billing privileges, deactivation of billing privileges. So to recap, they can deactivate for things like failing to submit claims for 6 consecutive months, not responding to the revalidation requests, including their development requests if they send any, failing to report changes. It's also important to understand that deactivation is essentially, like we were saying, it's a pause in billing privileges that can have a lot of ramifications that come afterwards for recoupment. And while it's possible for pharmacies to argue against this lapse in billing privileges through something like a rebuttal procedure, which would be detailed in your deactivation letter, we want to note that, these options come with tight deadlines that you need to watch out for. So for example, rebuttal letters, yes, you can argue the lapse, but those have to be submitted within 15 calendar days of getting that deactivation letter, typically in the mail. So we also note that if you get a development request, it's very helpful to try to contact the particular enrollment specialist that might be listed on that letter with their particular number to try to get more details about what happened on CMS's side, to try to avoid deactivation or using the rebuttal process if you can. The effective date of reactivation, if it gets to that point, is typically based on the receipt date of your reactivation application, which can also then cause a gap in billing privileges. So for deactivations where the pharmacy was not compliant with all enrollment requirements, they'll typically allow the pharmacy to submit a rebuttal. The contractor in that situation then reviews any documentation and records that you submitted to see if you were compliant at the time of deactivation. If they deem that you were, then they should approve your rebuttal and reinstate billing privileges, but you have to make that argument about not having a gap. For these procedures, it's crucial to include, again, best contact information on your applications, keep it updated, because the retroactive deactivation in this instance can lead to significant financial recoupment, and you don't know if they're going to agree that you shouldn't have had a lapse. So as we said, revocation means termination of the provider agreement. And as we stated earlier in the presentation, this can cause a re-enrollment bar, typically 1 to 3 years, but it can be more, which makes noting the deadlines for rebuttals, caps, reconsideration requests very important. So to recap, rebuttals to deactivations have to be received within 15 calendar days. Corrective action plans for a threat of revocation received within 35 calendar days, and reconsideration requests within 65 calendar days. But we note here that CMS, again, this can get really messy. They might not always send a decision on the cap that you sent in until well after your reconsideration request deadline has passed. So in that case, it's critical to keep track of whether you even received a decision. And then if you didn't, to be mindful that your reconsideration request deadline is coming up in order to preserve your rights. So just talk about the appeals process a little bit. If your billing privileges are denied or revoked, like we just covered, there are ways to contest these decisions. So the process includes, like we said, caps, filing reconsideration requests, rebuttals, and then even having hearings with an administrative law judge or an ALJ. And this way, you have multiple options to address and potentially reverse the adverse determinations.
You know, one other thing I just want to mention that's just slightly, it's related but a little off topic, is on the other, in terms of the things that can happen to you as a pharmacy related to your Medicare enrollment, is there's a preclusion list that's separate from what we've been talking about. It's something that generally comes up in the context of an audit, and the demonstration of some kind of fraudulent or pattern of abuse of billing type of practice by a pharmacy. If you end up on there, we'll talk again about some of the others, but if you end up on there, it's kind of, you're going to start triggering all of your other contracts getting canceled as well once you go on that list. It's kind of like double secret probation. You can't go pull the list. You can't see if you're on the list. But if you're on the list, you effectively know you're on it because everybody starts canceling you. So it's a little bit off topic. It's a separate list out there. And I'm sorry to interrupt you, Vanessa, but I thought it was important to sneak it in there because, as you get into the appeals process, that's yet just another thing that you can be appealing. But I digress. But go ahead, let them know all about the appeals process here because that's important.
No, it's important too. Thank you, Rob. We mentioned this a couple of times, but just to give you a little bit more detail on what goes into a CAP or corrective action plan, this needs to include some clear proof, evidence that you followed the Medicare rules, especially the ones that they're citing, be submitted within 35 days of receiving that notice. It has to be from a letter signed by you as an authorized official or your legal representative. So if a lawyer is your representative, then the CAP would state that we have the authority to act for you. If it's not a lawyer, then you would have to include a written notice of whoever the person is submitting it, that they were appointed and it's signed by you. And lastly, you should expect to receive a decision within 60 days of the contractor receiving the CAP.
So in practice, our experience is that it's taking more than 60 days. It's also very important that once the cap is submitted, that you're following up to make sure that the contractor actually received it, because there have been times where provider, or we have sent it in assuming that the contractor's reviewing it, but then once we follow up, that's the first time where they're even aware that they received the cap.
Yeah, they switched to a new organization to undertake these reviews, and it has been very, very slow. Um, so good point.
Actually, those same issues then, they will also apply to reconsideration requests. It's the same contractor who's now been appointed to deal with these as well. So it's a good point to bring up. And for reconsideration requests, in those, they're different than caps. It's similar, but it's a different process. It's a different way of explaining the arguments and the issues and the facts that you disagree with in the letter and why. That is a little bit longer because they expect those arguments to be in there. So you have 65 days to submit that within from receiving the initial decision. And then similar to the cap, you're writing a letter signed by you, an authorized official, or your legal representative with a similar procedure to the one that we just spoke about with the cap. And with this one, again, with the caveat of what we were saying before, typically you should expect to receive a decision within 90 days. But again, it takes follow-up and may not always be in that time frame. So for administrative law judge or ALJ hearings, if you are unhappy with the outcome of a reconsideration request, then you can request a hearing before an ALJ. And this hearing would let you present evidence and arguments in person. And in terms of deadlines, the request for an ALJ hearing has to be filed within 60 days of the reconsideration decision. And you want to be well prepared in order to present all of the relevant evidence and the legal arguments that you might have. If the 60-day window is missed, you can submit a written request for an extension that could be filed explaining why, if there was good cause. The ALJ might extend the deadline if there's a good reason. And lastly, the ALJ will issue a written decision, a dismissal order, or it will remand the issue back to CMS. The Departmental Appeals Board or DAB reviews, if you then disagree with the ALJ's decision and it's unfavorable to you, then you can request a review by the board. And this request has to be filed within 60 days of receiving the ALJ's decision or dismissal notice, and the board might also extend this time for good cause, for good reason. If the board review, what they'll do is they'll check if the ALJ's decision was actually based on substantial evidence and if it followed the law. So again, here you want to make sure that you're including all relevant evidence and your legal arguments in your review request. For judicial reviews, so this is the last step. Lastly, these involve asking a federal court to review the board's decision, and this is typically the final stage in this appeals process. So here you would have to file a civil action in federal district court within 60 days of getting the board's decision. And this is, the whole process really, but also here having legal representation can be very helpful to navigate all of these complexities of federal court procedures and just most of these processes in general. So we're going to just turn to site visits. Site visits are done to verify compliance with the Medicare enrollment requirements and the supplier standards, and they're mandatory for what's considered a high-risk provider like DME POS pharmacies during initial enrollment, revalidation, and then whenever you add a new location. And when CMS labels a provider as high risk, it means that they're going to perform several screenings, including fingerprint-based criminal history checks for folks with significant ownership interest. And you want to be aware that CMS can perform these unannounced site visits. So you always want to be prepared by keeping those accurate forms and documentation that we were talking about in all of your up-to-date records. It's just talking about the role of these national site visit contractors. They conduct site visits on behalf of CMS, and they perform both external and internal reviews during these unannounced visits. They're usually during normal business hours, and they'll verify practice location information. They might interview staff, assess inventory, review documents like the complaint logs, warranty information, the rental protocol, and purchase agreements. So we mentioned this before, but you want to keep in mind that the site visits can be very quick. So you want to ensure that all of the documentation is available in one place and easily accessible to give to the surveyor. So based on site visit findings, CMS can take various administrative actions. They could, like we're saying, revoke, deactivate, impose corrective action plans. Some of the common issues that can lead to these actions include non-operational practice locations, again, unreported changes, failure to maintain compliance with the standards. So it's important to promptly address any of these deficiencies, especially if they're identified during a site visit. And then the collateral effect of Medicaid disenrollment. So pharmacies that don't have or maintain 855S enrollment with Medicare, when it's required for their pharmacy type, may not meet New York State Medicaid enrollment criteria. And then the collateral effect is that you could be disenrolled from Medicaid as well. And examples of pharmacy types that do require 855S enrollment include closed door, long-term care pharmacies, open door community pharmacies who are also providing immunization services, open door community pharmacies with practitioner administered drugs, and closed door infusion and specialty pharmacies. So the majority of the pharmacies are going to need this enrollment.
Right. So just a word here. The triggering, the cascade to Medicaid, what we're focused on here right now is like that's certainly a New York centric issue. Not every state has that specific requirement. There are some that do, there are some that just don't. So just wanted to be aware because this was definitely focused kind of more broadly federal Medicare overall. As we cover these, I don't want somebody on here who's from a state that doesn't have that requirement starting to panic and post to the question and answer. By the way, if you want to post something in the Q&A, happy to address any questions anyone might have as we go along here. But just wanted to make that point. So thank you, Vanessa.
Sure. And I believe that's actually going to bring us to our last informative slide. So here we're just wrapping up with some key compliance tips that we have. So you want to regularly review and update your enrollment information, like we've been saying, keep it accurate. This includes checking your ownership details, practice locations, organizational changes. You want to conduct some internal audits to catch and fix any potential compliance issues before they turn into bigger problems. You might want to use the form itself to make sure that everything is always up to date as like a checklist. You want to keep a close eye on all CMS and Medicaid communications. Make sure that your contact information for both Medicare and Medicaid is current. And if it's, even if the email is current, check your spam folders because sometimes it can end up there too. You want to stay on top of deadlines for development requests that you might receive. And then if you do have to respond, rebuttals, caps, reconsideration requests so that you always have enough time to respond. Or if you do want to, retain legal counsel, it gives us enough time to help you as best we can with the time that you have left after you receive these letters. And then also to train your staff on Medicare requirements and just be sure to stress the importance of maintaining these accurate records. If a specific enrollment specialist is listed, again, make sure you save and use their contact information for any of these requests if it's provided. And with that last slide, we can conclude our presentation. And of course, if you have any questions.
Yeah, let me jump in with some overall thoughts here. You did a terrific job. It's a lot of important information for everybody. Excuse my phone. Lights up everywhere. Be aware that it's really about doing that extra level of diligence in the day-to-day operation of your school, of your stores and your pharmacies, of staying on top of things. Um, you know, there are a lot of ways for pharmacies to maintain compliance, whether it's with Medicare enrollment standards, Medicaid enrollment standards. There can be some overlap and similarities, but also in terms of your billing, and your practices, your inventory, and maintaining those things, because all of these things can trigger, and jeopardize your Medicare enrollment. So today we're talking about, are you staying on top of your 5% issue on the accreditation? Because when you fill out that paperwork, mind you, you're going to get asked for the backup, as many of you may know, from an accountant who's going to sign off and attest that you're really underneath that 5% threshold. Are you, submitting DME claims when you don't have the accreditation in place? Because that'll trigger things as well. So it's staying on top of that billing. And when you get into those issues, lo and behold, we're triggering revocation. When you get into these, staying on top, making sure you're following up that your documentation is where it's supposed to be going. We had a case, a good friend who's on here reminded me, related to, fingerprints being done and them being delayed, and little things can, snowball into really big problems. And, your reimbursements are your lifeblood. And if you're going to get hit with something, certainly on an administrative standard, you don't have the time or want to spend the resources to have to deal with those issues. So, the ounce of prevention will really, really help you. And as it relates to those billing items, inventory items, you start getting tagged in those, you're starting to hit the revocation and the potential for the preclusion lists. And that's the death knell, the nail in the coffin, because you're going to start getting notifications from your commercial plans that they're not doing business with you anymore, and everything is going to start drying up at that point. So, um, these things we've seen, we've had dozens and dozens of pharmacies coming to us the last 3 years on it. And so if you have questions or you need help, feel free to reach out. If you don't use someone like us, please use somebody with some real, expertise in this area, because you really need to know what you're doing, particularly as you venture into the appeals of this, and how to handle them, and understanding, how it works with administrative law judges, and talking to attorneys for CMS. And the last thing I'll leave you with here is healthcare compliance overall. Take a look at your billing. If you're New York, I'll just throw this out there for those joining from New York. If you're hitting $1 million in Medicaid, then that's combined Medicaid or any of the Medicaid managed care plans, you better have a compliance program that is updated to the new regs and in effect, and being, carried out effectively, not some paper sitting gathering dust that you're going to blow off when somebody comes in. All right. They're out there now. The regs changed last March 2023, and they're auditing. The audits of the compliance programs are flying in. Okay. We just last week alone, we got another 3, and they're covering everybody, small to large. And so, you know, feel free right now, so stay on top of that. Take a look at that. If that's something you need, if you need more information, it's on our website. We've done webinars on that too. You can always give us a call. And I love, getting, the folks on here who know me, sending me reminders with texts on here, like, yeah, if you mess up, that's right. Thank you, Jim. If you do mess up that surety bond, you can not only just get kicked out, but the next time you're back in, it doubles. So, Stay on top. It's all about staying on top of things. So with that, I'm going to leave the Q&A open for a minute here. If anybody has questions, please put them in there. Also, our contact information is here. Reach out to us if there is something on pharmacies you want us to cover. We have a compliance, it's a webinar series. We're hosting them monthly or every other month. We've been doing it for almost 2 years now on just trying to help providers. Reach out and say, Rob, I'd love to hear about, this particular topic. And, presumably it makes sense and we'll do it. So we're here, we're a resource, and we thank all of you for your time. And like I said, you'll get a copy of this. And thank you to my colleagues, Andrew and Vanessa, for doing a terrific job and putting a lot of work into getting all this information together for you. So thank you very much. Okay. No questions. I think we can end it at this point. Thank you, everybody.